Hi ma'am, I'm Alberto Torres from San Miguel Malaba, Bukidnon. I'm currently studied in Philippine Canterville College. And this is my blindfold oral examination about Article 11 to 15. First, Article 11, justifying circumstances. The following do not incur any criminal liability. First, anyone who acts in defense of his person or rights, provided the following circumstance concur. First, unlawful aggregation. Second, reasonable necessity of the means employed to prevent or repel it. Third, um, reasonable necessity of the means employed to prevent or repeat it. Um, Number two, anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or his relatives by affinity in the same degrees and those um, consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the preceding circumstances and present and the further requisite. In case the revocation was given by the person attacked, um, that the one making defense had no part therein. Third, anyone who acts in defense of the person or rights of a stranger, provided the first and second requisites mentioned in the first circumstance of this article, and present and that the person defending be not induced by the revenge, resentment, or other evil motive. Fourth, any person who, in order to avoid an evil or injury, does not act which cause damage to another, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than that done to avoid it. Third, that there be no other practical and less harmful means of preventing it. Number 5. Any person who acts in the fulfillment of a duty or in the law exercise of a right or office. Number 6. Any person who acts in obedience to an order issued by a superior for some lawful purpose. Article 12. Circumstances which exempt from criminal liability. The following are exempt from criminal liability. Number 1. An imbecile or insane person, unless the latter had acted during a lucid interval. Um, when the imbecile or insane person has committed an act which the law defines as felony The court shall order his confinement in one of the hospitals or is- asylums established for a person thus afflicted, which he shall not be permitted to live without first obtaining the permission of the same court. Number 2, a person under 9 years of age. Third, a person over 9 years of age under 15 unless he has acted with designment, in which case such measure shall be proceeded against in accordance with the provision of Article 80 of this code. um, uh, when such measure is adjudged to be criminally irresponsible, the court in in conformable with the provisions of this and the preceding paragraph, shall commit him to the care and custody of family, who shall be charged with his surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in said Article 80. Um, uh, Number 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Number 5. Any person who act under the compulsion of irresistible force. Number 6. Any person who acts under the impulse of uncontrollable fear of an equal or greater injury. Number 7. Any person who fails to perform an act required by law when prevented by some lawful insuperable cause. Chapter 3. Circumstance which um, mitigate criminal liability. This is Article 13. Mitigating circumstances. The following are mitigating circumstances. Number 1. Those mentioned in the preceding chapter, when all the requisites necessary to justify to exempt from criminal liability in the respective cases are not attended. Number 2. That the offender is under 18 years of age or over 70 years. In the case of murder, he shall be proceeded against in accordance with the provision of Article 80. Um, Number 3. That the offender had no intention to commit so grave a wrong as the committed. Number 5. That the act was committed in the immediate vindication of grave offense to the committing the felony in his spouse, descendants, or relatives by affinity within the same degrees. Number 6. That all of having acted upon an impulse so powerful as naturally to have proceed, passion, or obfuscation. Number 7. That the offender had voluntarily surrendered himself to a person in authority on his, or that he had voluntarily confessed his guilt before the court prior to the presentation of evidence for the prosecution. Number 8. That the offender is deaf and dumb, blind, or otherwise suffering some physical defect with those restrict his means of action, defense of communications with his fellow beings. Number 9. Such illness of the offender as will diminish the exercise of the will of power of offender without, however, depriving him of the consciousness of his acts. Number 10. Finally, any other circumstances of similar nature and analogous to the above mentioned chapter 4. Circumstances which aggravate criminal liability. This is Article 14. Aggravating circumstances. The following are aggravating circumstances. First, the advantage be taken by the offender of his public position. Second, that the crime be committed on the concept or with insult to the public authorities. Number 3, that the act be committed with insult or in disregard of the respect due to the offended party of account of his rank, age, or sex, or that is be committed in the dwelling of offender party and later has not given provocation. Number 4, that the act of be committed with abuse of confidence or obviously ungratefulness. Number 6, that the crime be committed in the palace of chief executive or his presence or where public authorities are engaged in the discharge of their duties or in place dedicated to religious worship. Number 6, that the crime be committed in the night time or an inhabited place or by bond whenever such circumstances may facilitate the commission of offense. Whenever more than 3 armed malefactors shall have act together in the commission of an offense, it shall be deemed to have been committed by a band. Number 7. The crime be committed on the occasion of conflagration, shipwreck, earthquake, epidemic, or other calamity of misfortune. Number 8. That the crime be committed with the aid of armed men or person who ensure or afford impunity. Number 9. That the accused is a recidivist. A recidivist is one who at the time of his trial for a crime shall have been previously convicted by the final judgment of another crime embraced in the same title of this code. Number 10. That the offender has been previously punished by the offense to which the law attaches an equal or greater penalty or for 2 or more crimes to which attaches a lighter penalty. Number 11. That a crime be committed consideration of a price, reward, or promise. Number 12. That a crime be committed by means of an addition, fire, poison, explosion, stranding, or a vessel, or international damage thereto, derailment of a locomotive, or by the use of any other artifice involving great waste and ruin. Number 13. That the act be committed with evidence premeditation. Number 14. That the craft, fraud, or disguise be employed. Number 15. That advantage be taken or superior strength or means be employed to weaken the defense. Number 16. The act be committed with treachery. There is treachery when the offender commits any of the crimes against the person employing means, methods, of forms in the execution which tend directly and specially to ensure of execution, without risk to himself arising from the defense which of the offender party might make. 17. That means be employed or circumstances brought about which add ignominy to the natural effects of act. Number 18. That a crime be committed after an unlawful entry. There is an unlawful entry which an entrance of crime, a wall, roof, floor, door, or window be broken. Number 20. That a crime be committed with the aid of person under 15 years of age be means of motor vehicles, motorized watercraft, airships, or other similar means. Number 21. That the wrong done in the commission of the crime deliberately usemented by using of chapter 5. Alternative circumstances. This is article 15. Their concept. Alternative circumstances are those which must be taken into consideration as aggravation or mitigation according to the nature and effects of crime and other conditions attending its commission. They are relationship, intoxication, and degree of instruction and education of offender. That alternative circumstances is the relationship shall taken into consideration which the offender party and the spouse, descendants, legitimate, natural, or adopted brother or sister or relative by an affinity in the same degree of the offender. The intoxication of the offender shall be taken into consideration as mitigating circumstances which the offender has committed a felony in state of intoxication. And the same is not habitual or subsequent to the plan to the commit said felony, but when the intoxication is habitual or intentional, it shall be considered as aggravating circumstances. Um, that's for all, ma'am. Thank you for listening my blindfold oral examination. Thank you and good night.